going to change, it would make sense to just take a look at what exactly is fire and rehire and what is the current legal framework, how is it governed at the moment. So we'll take a look at that. So don't worry if you don't have a good starting knowledge on fire and rehire, we'll cover it very briefly and as much detail as we can with the time we've got today. We'll then go in to actually look at what's going to change when the Employment Rights Bill is implemented in detail. And we'll finish up, as always, on some practical tips for employers, things you could be doing just now to ready yourself for these changes. This morning's is quite legally technical and a bit jargony, so I'll try and break it down as best I can, but there'll be a chance for questions at the end. Or we've actually got quite a small group today, so if you even put something in the chat, I'll try and pick it up as we go through because it's a bit more of a technical one. So what is fire and rehire? Fire and rehire, will you also use the term dismissal and re-engagement? That's its more kind of formal title, but fire and rehire tends to be what it's labelled as in the media and how it's more commonly referred to. But it's basically the practice of dismissing an employee or a group of employees, but immediately re-engaging them on a new employment contract, which has different terms, and they're quite often more favourable terms in some way, whether that's, less favourable pay conditions, hours of work. In of itself, it's not outright illegal in the UK, but it is heavily scrutinised. That's both, tightly governed legally and within the media, the press, even from like an employee relations perspective, it tends to be heavily scrutinised. You all probably remember a couple of years ago there was the P&O Ferries scandal where they dismissed a huge group of staff and immediately re-engaged agency workers that were cheaper for them to do that work. Tesco as well actually were in the news. They'd dismissed and re-engaged, and that was to like work out a historic union agreed kind of more favourable pay term that they wanted out the contracts. So they've been in hot water over it before as well. And off the back of that, some more kind of legal framework did emerge, which we'll take a look at. And it doesn't tend to be an employer's first port of call. I imagine it would be extremely rare, if any, that an employer would go to this first. This tends to be used as a tool when an employer, for some reason or other, can't get agreement from staff to change contracts. So perhaps they've gone through a lengthy consultation process and they've been unable to get that agreement to make the change they're looking to make. So historically, this was something, it could be a last resort tool, but you'll see as we go through today how I think the new legislation, while not outright banning it, still is making it kind of so difficult that it's hard to even say it will be an option going forward. So I mentioned that some more the legal framework changed slightly in response to some of these big media scandals. It was actually the Conservative government that put out this statutory code of practice on dismissal and re-engagement. I've hyperlinked it within the slide itself, so everyone who's on the call will get a copy of these slides, and you can go and take a look at it. It's not overly long and it's written in pretty user-friendly language, so if you've never had a look, it's not a bad one to take a read through at all. So this is actually fairly new. This was only brought into force in July 2024, so it's not an old document. And it sets out the requirements, steps that an employer must take before they either consider or go ahead and fire and rehire or dismiss and re-engage, the language they use. It's going to be out of date soon, so without going through it in too much detail, I've picked out like the kind of key requirements within that code, which make up the current expectations and the current law surrounding dismissal and re-engagement. The first kind of thing they go quite heavy on is information sharing. So that's making sure whatever the proposal, whatever the contract change you're trying to bring around, is properly presented and given to employees, in writing, so they're clear exactly what the employer's proposing to change. And they say that that should be with the appropriate personnel. So they give examples. So that might be individual. You might be going to your staff individually on a one-to-one basis. You might have an employee representative forum that you use for these types of contract changes. So you might be going to them with that information at the outset. Similarly, you might be a employer or have a part of your workforce that's under a collective bargaining agreement. So it'd be a trade union representative that you would go to this information at the outset if that's a feature of your agreement. So it's just about making sure you share that information up front at the outset. And then what the code goes on to say is that once that information's been shared, you should go on a kind of meaningful consultation process with the impacted employees. Now, they use this word meaningful. The kind of things they're looking at is the length of the consultation period. So they don't put like a set time limit on it. They don't say a minimum of 3 months or 2 months. They really do say that it needs to be as long as it needs to be to have that back and forth. So the consultation period really lasts as long as it takes to put your idea or proposal to the employees, get their feedback, maybe they have counter proposals, respond to them. So it's not something that it'll be easy to put a kind of hard stop on. They say that it should go on as long as it needs to either reach that impasse or gain agreement. They also say that the consultation process, there should be evidence within it of the proposals put forth by the employee being considered. So I think that's to get away from, a tick box exercise. You want to be able to evidence that an employee's come in with a counter proposal. You've gone away, looked at it, tried to review whether it's feasible, possible. Is there some version of it you can go back to them with? And that's been communicated back to them. And they say that the consultation should be with the view to reach an agreement. The next part they say is quite interesting because they say that there should be transparency with employees at some point through that consultation process, that there could be a prospect of fire and rehire if changes aren't agreed. But what they say is that it shouldn't be brought up, really early in the process, because that could almost be seen to like coerce them into signing if they think that that's going to be the alternative. It should only really be raised at the point where you've gone out, consulted, you've tried to go back and forth on counter proposals, but it seems like you're not going to be able to reach agreement. And they also say at that point that you should contact ACAS. So that's a bit of a new role for ACAS. And within the code itself, and it's not entirely clear what ACAS will do in a practical sense. And there's not been any kind of case law on it to test or to examine what ACAS will actually do. But they do offer a similar service to assist with trade unions and pay disputes. And that team actually comes in and will have a bit of a practical role in trying to mediate between the parties. So I'd imagine it'd be something similar, but you'd want to be able to show that at that point when it looks like it's a real option, you've gone to ACAS and taken up any support that they might be able to offer. And then this one is quite interesting as well. Once you've done that, you've raised it, fire and rehire as a prospect, taken any support that ACAS might have. There's almost like a reconsultation required, because at that point, if you've not reached agreement, they say that the employer should really go back to the root of the proposal, the kind of business rationale, and re-examine the proposal. So in light of everything that's been raised, is it still necessary? They say that you should take on any feedback that you've had from employees throughout the process to see if you can amend the proposal, or if there's another way you can pitch it. And if that's the case, it would almost involve a kind of reconsultation of the proposal based on any kind of amendments you've made to it. So you would need to be able to show that you've done that as well. And then finally, the code kind of ends on your options at that point if you don't have agreement. And dismissal and re-engagement at that point is really framed as the ultimate last option. So if you were ever in a situation where you were considering that, you would need to kind of go through this guidance and make sure you can evidence that you've gone through kind of every step in this code. And you'll probably see from even that kind of high level overview that it's pretty onerous, and there's a lot of steps there that employers have to take before they can consider dismissal and re-engagement. So this is what came out off the back, of things like the penal scandal, and this was from the Conservative government. One of the other features was that they gave this kind of a statutory teeth. So if you don't follow the code, any sort of appropriate tribunal claim, so like unfair dismissal, unlawful deduction from wages, if you dismiss and re-engage and you fell short of any part of the code, they can increase awards at a tribunal by up to 25%, depending on the severity of the deviation from the code. So it's not just like a guidance document you'll see there, it's like a statutory code that needs to be adhered to. So that is the position currently, what we have in place currently, pre-Employment Rights Bill. You'll probably appreciate from going through that section that there are a lot of risks involved with dismissal and re-engagement, fire and rehire. In terms of claim risk, I think the kind of main one will be either ordinary or constructive dismissal. Constructive dismissal being where an employee believes that they've been treated kind of so badly that they're entitled to like rip up the employment contract. Their treatment's almost amounted to like a fundamental breach of trust and confidence between them and their employer. So that turns like the resignation into a dismissal because there's been that kind of fundamental breach in the relationship. So I suppose if you have employees, right now you need 2 years to make these claims. That's obviously going to change with the Employment Rights Bill as well and become a day one right. However, that's obviously a risk there if the process has been handled, improperly, that you have a risk of a number of these claims from the impacted employees. There could also be, unlawful deduction from wages or breach of contract claims, particularly if they then start to be paid a lesser amount under the new contract. You could see these come in. Always a kind of risk of discrimination claims. So if within your pool of impacted employees who you've dismissed and re-engaged, you maybe have people with disabilities or other protected characteristics, and they're proportionally kind of disadvantaged from the new terms, then there's a risk of, discrimination claims stemming from the exercise as well. And I think particularly with dismissal and re-engagement, we're normally quite focused on claim and risk because that's financial risk. But I think you just do have a more heightened risk of really negative press and employee relations issues if you go down the route of dismissal and re-engagement. And that's why it's very rarely something that would be advised. You'll probably know yourselves that the kind of golden way to agree a contract and really the first position is to consult on it and get employees on board with the changes and agree to the changes. So that's where we're at as of today, and this is a look at the proposed changes within the Employment Rights Bill. The bill's still going through the legislative process, but we've got a good amount of detail in there of what the changes to the fire and rehire regime will be. So the key one is that they're going to make it automatically unfair to dismiss an employee for refusing to accept what they call a restricted variation. So this would be completely new in law. Maybe helpful just for a brief explanation of what automatically unfair dismissal is. Automatic unfair dismissal will mean that there's a list of kind of different things. So this might be right now things like whistleblowing. It can be things like if you raise a health and safety matter. It can be things like, taking statutory leave. If someone's dismissed for these types of things, it's automatically unfair if they can prove that the reason for their dismissal was, wholly or mainly because of that thing. There's no argument that it was reasonable. There's no examination of the process to show you've carried out a fair process. It's just automatically unfair. So you can see there how that's higher risk. There's also no requirement on service to make a claim of automatic unfair dismissal. That would be from day one of employment. An employee can make a automatically unfair dismissal claim. So under the kind of different categories of reasons that people can claim automatically unfair dismissal, refusal to accept a restricted variation is going to join that list. So they have gone on to define like what types of contract changes are going to be restricted variations. And the ones we have so far is any sort of contract change about pay and pension, anything about working hours. So, that might be the total number of hours per week. It might be the start and finish or the duration of like specific shifts. We've also got any sort of contractual time off or holidays. If they are changed, that would be a restricted variation. And another interesting one is variation clauses. So, if once this is enacted, you try to put a variation clause in someone's contract and they're dismissed as a result of not accepting, that would be automatically unfair. But we'll look a bit closer at variation clauses in a moment. And then they've added that kind of caveat within the Employment Rights Bill, which basically means we might get more restricted variations in due course, because they've said any other changes defined by Secretary of State. So that would be in any future regulation. They might expand this, they might clarify things for us in the future. So in terms of variation clauses, you'll see here that this paints a pretty stark picture, because arguably this is going to cover more than just dismissals for the purposes of dismissing and re-engaging. I've seen a lot of academic writing, a lot of employment law blogs, thinking about kind of hypothetical situations where a dismissal might be captured as automatically unfair, particularly if there's some sort of business need where an employer needs to react and enact a change. Perhaps it's in a reorganisation off the back of a business implementing a new structure. An employee doesn't accept a restricted variation, it later leads to redundancies. This arguably creates a situation where those later dismissals, if they're linked back to the initial refusal to accept the contract changes, could be automatically unfair. So you can see how there's a general fear that this is going to create a lot more inflexibility when it comes to changing contracts. And the bill at present, it doesn't say anything about variation clauses that are already in place being captured by this, which is leading people to the kind of general conclusion that if you have an existing variation clause in place in employment contracts, so something that says, we reserve the right to amend your hours of work in line with operational requirements, if that's already in pre this coming in, it might offer you some flexibility to be able to make changes without getting in this type of territory. And we'll look at that in more detail at the practical tips section at the end. Now, there isn't going to be an exception to this, but the exception itself, you'll see it's going to be of limited application. So they've said that the dismissal won't be automatically unfair, where the reason that the employee had to make the restricted variation was to eliminate or mitigate financial difficulties that they were having at the time of the dismissal. But what they say is that those financial difficulties must impact the employer's ability to carry on the business as a going concern. So it really needs to be financial difficulties to the point that you're looking at a business closure. So you've had to make those restricted variations to contracts, or the business wouldn't continue at the time of the dismissal. It can't be for issues sometime in the future. So it can't be that you've had to make these changes because there's been a downturn in business and you expect that in a forecast in a year's time you'll be in that situation. The way the Employment Rights Bill was worded is that it needs to be, you know, pretty imminent at the time of dismissal. And the second kind of exception is that the employer couldn't have reasonably avoided the need to make the variation. So I think that will involve some sort of assessment by a tribunal that you've exhausted all other options short of making that variation to try and fix it before going down that route. However, if an employer can demonstrate that they were in this quite extreme financial position, and that's why, you know, they had to make the variations and the dismissals, it doesn't mean that the claim is resolved. It then just means it's not automatically unfair. It would then fall to normal tests for ordinary unfair dismissal. So it means that you'd have a shot at showing, but we made a dismissal for a potentially fair reason, and we acted reasonably, we followed a fair process. So you'd be able to argue all this reasonableness to try and, you know, defend the claim. These are the types of arguments that you can't make in an automatic unfair dismissal claim. In terms of things I've read, because this is all new, I've seen a lot of kind of commentators say that they think that they're going to see more financial incentives being given to employees in exchange for signing up to changes within the employment contract. So it might become a bit more of an expensive exercise, but also some worries from some commentators that it could create a potentially two-tier workforce, with those who accept changes, you know, being on more favourable terms, and those who haven't, not having those favourable terms and having lower pay. So I worry there, as well as the worry that this is going to affect more than just dismissal and re-engagement, and the kind of rigidness that this could create for businesses. Another mention, not as big a change here, but just a mention that Section 28 will also make it automatically unfair to dismiss an employee to replace with someone who's not an employee. So that covers the kind of situation I spoke about earlier with P&O, where they dismiss an employee and replace with the agency worker that was less expensive. So this would capture that situation and make that unlawful. Again, subject to certain provisions. The individual needs to be taken on a contract for the employer's business to undertake activities. Those activities they're doing under the contract need to be the same or substantially the same as the employee did for the employer before. And the employee's dismissal mustn't be like a redundancy situation. So if the reason for the dismissal was that the requirement for them to do that work is ceased or diminished, this wouldn't kick in. So just a quick mention on that, that's also included in that section. In terms of the impact of these changes, the government have said that the statutory code will be updated to reflect these changes. So that's the one that was announced last year, we went through at the beginning. So we will see that updated. So it'll be interesting to see what the government are going to recommend in light of these changes. They've said further consultation will open in autumn 2025. So they've not said what questions they're going to ask, but it might be worth putting a note in your diary. I'll certainly check for that, see what they're asking, and if you have any relevant information from your business that you think will assist the consultation, you can participate in that. I've hyperlinked the implementation plan there that we referred to last week, just in case maybe anyone missed that session and wants to go on and have a look. They've said that this will come into effect on the 1st of October 2026. So that really gives us about a year to ready ourselves to bring our documentation and our processes in line with these changes, which I think probably brings us on nicely to the practical tips that we could maybe be doing just now. So I would say act early on this, review your contractual documentation, your contracts, if you're an organisation who's any contractual policies, and have a think about whether, based on the way your business operates, do they have enough flexibility for you? You know, for example, if you're a business who relies quite heavily on shift work, um, and you foresee needing to change the shifts, what do you say about being able to change shifts in your contract? What I would say is, in general, variation clauses, flexibility clauses, um, are a bit difficult to enforce legally. They need to be drafted in quite a specific way. So it's definitely one that if you want to add in a variation clause or a flexibility clause, you probably want to take legal advice on that just to make sure it's as fit for purpose and usable as possible. Just to increase the likelihood of you actually being able to use that. So that might be things like, you know, if a contract says that an employee works a day shift, but you've just said a general, we reserve the right to amend the shift. You'd really want to be a bit more specific to that and say, what are the particular shifts they might be moved to? Is it a back shift, a night shift? What hours are they? How often do you keep the shifts under review? Do you review them maybe twice a year? And you know, what's the notice for any shift changes? Will they be notified of any information from any reviews of the shifts? So you'll see, for it to be as specific as possible, and have as much information as possible will increase the enforceability. So it might be worth seeking some advice if you're looking at adding that in the contracts. And again, although you're bringing these in before these changes are implemented, you would still need to have them agreed with employees now. I would say as well, just if you're doing any consultation exercises, once the new code of practice is available, I would review it and just familiarise yourself with it, because I would say that that's a good starting point to make sure you're following if you're doing any of these kind of consultation exercises. I think it'll be more important than ever just to make sure that they're all fully documented. So if you're doing one-to-ones, if you're doing further investigation, that you can fully evidence the process you've followed. You'd want to be able to show that you've taken the consideration that was brought to you in that consultation and that you've investigated it and responded to it. And I think the picture that the new changes does paint is that it's not going to be so easy to go out with the change you might have in mind or you might want as your first option, and guarantee that's going to, you know, be secured through agreement. I think it's about, you know, being prepared to find a kind of middle ground or make changes to your proposal based on the feedback you get to try and get that agreement. I think more important than ever. Again, just following the process and avoiding any shortcuts, and ensuring that any dismissals you make have that genuine financial justification, and are the kind of last resort. I think if you're ever considering dismissals off the back of a contract change exercise, certainly take legal advice. Take it early, take it throughout, but particularly around that area, because you'll see it's a pretty high bar to get in that financial difficulty exception. And monitor developments. There's a lot of parts of this that say to be regulated further by the Secretary of State. We're also seeing the consultation open in autumn 2025, so soon. That might lead to amendments based on what comes out of that consultation. So worth just staying informed on this one particularly. And as always, we'll continue to review things as they progress and update members. That's us for this morning. I appreciate that was a bit of a gallop through and quite a lot of information. If anyone has any questions, happy to take them. And I'll kind of hang on as well if anyone has anything they need to chat about. Thank you for that wee clap. I appreciate that.